On behalf of the London Shipping Law Centre and 36 Stone, I would like to extend a very warm welcome to our distinguished chair, the Honourable Mr Justice Andrew Baker, my co-panellists for this event, Mr Richard Sarll of 7 Kings Bench Walk and Mr Richard Gunn, the global head of the Reed Smith Casualty and Admiralty team, and to you, the audience. This event, in which we will be considering hot topics in Admiralty, is the 7th in the LSLC's global webinar series and has attracted over 370 delegates from 45 countries. Without more ado, let me say a few words about our chair. Sir Andrew was appointed to the High Court bench in May 2016, following an illustrious career spanning some 27 years at the commercial bar, where he specialised in dry shipping and allied fields. In August of 2020, Sir Andrew was appointed to succeed Sir Nigel Tier as the Admiralty Judge. Thank you very much, Sir Andrew, for agreeing to chair our event. Sir Andrew, over to you now.
Thank you, Vasanti. Good evening or good morning or good whatever time of day it may be, depending on where in the world you have connected from. It is, as it always is, a privilege and an honour to be invited by the LSLC to chair one of their events. This I do for the first time this evening, having taken on the role of Admiralty Judge, as Vasanti has mentioned. There is still that little part of me that feels slightly a sheep among wolves, or perhaps a wolf among sheep. I'm not quite sure, having, I would confess, been far more of a dry shipping than a wet shipping practitioner myself. But it's a particular privilege and honour to have taken over from Sir Nigel on his retirement, and to have the chance, therefore, to chair this evening's discussion on, indeed, as Vasanti said, hot topics in Admiralty. It is nice on occasion to find an overarching theme. I'm not sure there is one this evening, other than that we're addressing recent developments or points of interest in the field of Admiralty litigation, unless it is perhaps this, namely that despite its centuries of tradition, there are always new things to learn, there are always new controversies to deal with, and in sequence we'll hear first from Vasanti as to the new things it turned out we had to learn from the Supreme Court on the collision regulations, from Richard on the new things it turned out were waiting for us to learn in the context of port dues, in particular when ships are arrested, a COVID story of the collapse of the cruise market, and then potentially most topically, and it may be most controversially, a bit of a panel discussion led by Richard Gunn on the threatened or possible developments in relation to the Lloyds open forum system of salvage and salvage arbitration. And without more ado, I will not spend time introducing our panellists more than that. You have their biographies and they will all be well known to you in any event. Vasanti, over to you.
Thank you very much. The Supreme Court delivered judgment earlier this year in the matter of Evergreen Marine UK Limited and Nautical Challenge Limited. And it was a case arising out of the collision between the appellant's part-laden container ship Eversmart and the respondent's VLCC Alexandra 1. A confession here, I appeared on behalf of the Alexandra 1 interests and had represented them in the courts below. This case was the first time in nearly 50 years that the highest appellate court in England has heard a collision liability appeal, the last case being the Savina in 1975. If we go to the next slide, please. The collision itself occurred late at night at 23:42, which you may just be able to see on that slide, local time, on the 11th of February 2015. And it occurred in the pilot boarding area, which lies at the seaward end of a narrow channel, which you can see marked there, leading into and out of Jebel Ali in the United Arab Emirates. The features on the chart that you can see hopefully are self-explanatory. Perhaps I just ought to indicate that the pilot boarding area is denoted by the circular area that you can see marked with dots at the top of that narrow channel. An agreed plot of the collision was able to be produced by the parties using the VDR data from both ships, and this is what you see on the screen. Alexandra 1's positions are marked in red, while those of the Eversmart that was proceeding up the narrow channel are marked in black. Alexandra 1 was in the pilot boarding area, waiting to board a pilot and then proceed down the narrow channel. Now at 23:28, or C-14, i.e. 14 minutes before collision, the master of the Alexandra 1 unfortunately misheard a VHF conversation between port control and a tug called the Zakir Bravo, and he mistakenly thought that port control was speaking to the Eversmart. This caused Alexandra 1 to fail to alter course to starboard at C-5 minutes in order to line up with the starboard side of the approaches to the narrow channel. And the effect of not turning to starboard at that time was that the Alexandra 1 continued heading so as to cross the approaches to the channel, albeit very slowly. From 23:32, or C-10, Eversmart was navigating to the port side of the mid-channel line, and thus she was on the wrong side of the channel, in breach of what we will see in a moment is Rule 9 of the collision regulations. Eversmart disembarked her pilot at C-6, after which, as the Admiralty judge found at trial, Eversmart wholly failed to keep a lookout. In addition, she then progressively increased speed from half ahead to full ahead, and then to full sea speed. Eversmart passed the number 1 buoys, which are the last buoys marking the end of the channel, at C-2, that's 23:40 local time. 30 seconds before collision, port control contacted Eversmart to ask if she was clearing to starboard. Her master then ordered hard to starboard, but collision was not averted. At the point of collision, Alexandra 1 was still in the pilot boarding area, with her bow on about the centre line of the channel, projected forward from the number 1 buoys. Her speed at collision was 2.4 knots, while that of Eversmart was 12.4 knots. 6 minutes after collision, the audio record obtained from the VDR shows the master of the Eversmart reporting the collision to his owners in the following terms. Quote, "We hit her because she stopped outside waiting. We were leaving port. We did not see that. I saw the light, but we didn't know she was transverse, so we knocked against her bow." At the trial, Sir Nigel Tier, who was then the Admiralty judge, after a careful review of the authorities, held that the crossing rules under the collision regulations cannot have been intended to apply where one vessel is navigating along a narrow channel and another vessel is navigating towards that channel with a view to entering it. He found that the Alexandra 1's duty as a matter of good seamanship was to navigate in such a manner that when she reached the channel, she would be on the starboard side of it in accordance with the narrow channel rule, which is Rule 9 of Coal Regs. He was heavily critical of Eversmart's breach of Rule 9, also her defective lookout and her excessive speed, and he apportioned liability, holding Eversmart 80% to blame. He also found that the crossing rule additionally did not apply because Alexandra 1 was not on a sufficiently defined course. Now, when the matter got to the Court of Appeal, permission having been granted by the Court of Appeal, The Court of Appeal, which included Lord Justice Gross, who many of you will remember as being an Admiralty specialist in his day, together with Lord Justices Lewison and Leggett, agreed with Mr. Justice Tear's reasoning and held that the crossing rules didn't apply for two main reasons. Firstly, because it could not reasonably have been intended by those who had drafted the coal regs that a vessel in a narrow channel, like Eversmart, must simultaneously comply with a narrow channel rule, which obligates her to keep to starboard, and also by the crossing rule, which might tell her to do something different by directing her to keep her course and speed. Secondly, it was held that the crossing rules didn't apply in any event because Alexandra I, as the putative give-way ship, was not on a sufficiently steady course for the crossing rules to be engaged, it being insufficient for the stand-on vessel alone to be on a steady course in order to trigger the application of the crossing rules. The Supreme Court gave the Eversmart interest permission to appeal on two questions of construction of the collision regulations, and they appear on the next slide. The first was whether the crossing rules are inapplicable or should be disapplied, where an outbound ship is navigating within a narrow channel and has a vessel on a crossing course approaching the narrow channel with the intention of and in preparation for entering it. And the second question is whether it was necessary for the putative give-way ship to be on a steady course for the crossing rules to be engaged. Now, before turning to the nub of the Supreme Court decision, it might be helpful to remind ourselves briefly of the content of some of the key rules within the collision regulations, which form part of the important background to their construction. So if we could go to the next slide, please. So here we have rules 15 and 16. Rule 15 provides that where you've got two power-driven vessels which are crossing so as to involve risk of collision, the vessel which has the other on her own starboard side shall keep out of the way and shall, if the circumstances of the case admit, avoid crossing ahead of the other vessel. And then Rule 16 directs that every vessel which has to keep out of the way of another ship shall, so far as possible, take early and substantial action to keep well clear. If we go to the next slide, we can see Rule 17, the action by the stand-on ship. And we can see that 17A1 states that where one of two vessels is to keep out of the way, the other shall keep her course and speed. And then there are modifications to those principles where there is a permission to take action where the stand-on ship, by her manoeuvre alone, it becomes apparent to her that the other vessel is not taking appropriate action in compliance with the rules. And then secondly, where from any cause the vessel required to keep her course and speed finds herself so close that collision cannot be avoided by the action of the give-way vessel alone, she shall, i.e. a mandatory duty to take such action as will best aid to avoid collision. And then it stresses at the end, this rule does not relieve the give-way ship of her obligation to keep out of the way. If we then go to the narrow channel rule, as I've indicated earlier, that mandates a vessel proceeding along the course of a narrow channel to keep as near to the starboard edge of that channel as is safe and practicable. And it was common ground in that case that the relevant entry and exit channel into and out of Jebel Ali was such a narrow channel. Other relevant rules included Rule 7A, whereby every vessel has to use all available means appropriate to determine if risk of collision exists, and if there's a doubt, then that risk is deemed to exist. And the risk in particular is deemed to exist if the compass bearing of an approaching ship does not appreciably change. And then Rule 2, the overriding good seamanship rule, nothing in these rules should exonerate any vessel from the consequence of any neglect or failure to comply with these rules, or of the neglect of any precaution which may be required by the ordinary practice of seamen or by the special circumstances of the case. Now, the Supreme Court, which consisted of Lord Lloyd Jones, Lord Briggs, Lady Arden, Lord Hamblin, and Lord Burrows, allowed the appeal on both questions of construction. And we've got the answer to the first question up on the slide there. The Supreme Court developed this proposition: where an outbound vessel in a narrow channel is crossing with an approaching vessel so as to involve a risk of collision, the crossing rules are not overridden by the narrow channel rules merely because the approaching ship is intending and preparing to enter the narrow channel. The crossing rules are only overridden if and when the approaching vessel is shaping to enter, adjusting her course so as to reach the entrance on her starboard side of it on her final approach. And the Supreme Court considered that the crossing rules are at the heart of the scheme for collision avoidance, and that it was necessary to differentiate between three broad groups of cases. So in group one are vessels which are approaching the entrance to the channel, heading across it on a route between start and finishing points unconnected with the narrow channel. Such vessels may approach the entrance to the channel, but they're not intending or preparing to enter it or shaping to enter it. In this group one situation, the crossing rules apply. Contrast that with group two, which concern vessels which are intending to enter the channel and are on their final approach to the entrance to the channel, adjusting their course so as to arrive on the starboard side of it, already shaping to enter it. Here, the crossing rules do not apply, and the narrow channel rule does. Finally, group three are approaching vessels which are also intending and preparing to enter, but which are waiting rather than actually entering, and which have not yet begun to shape to enter the channel by adjusting their course and speed so as to arrive on the starboard side of the channel. In this group, the crossing rules do apply, and into this group, Alexandra 1 was held to fall. The Supreme Court clarified that in relation to Eversmart, the fact that she was the stand-on ship did not literally mean that she had to maintain her precise course or speed. And as they stated in paragraph 140, quote, keeping her course and speed includes doing so in compliance with any other applicable rule. So if we go to the next slide, we can see the answer to the second question. If two vessels moving over the ground are crossing so as to involve risk of collision, the engagement of the crossing rules is not dependent upon either the give-way ship or the stand-on ship being on a steady course. The Supreme Court found that there was no textual justification in the coal regs requiring two crossing ships to be on steady courses before the crossing rules were engaged. In particular, there was no need for either the stand-on ship or the give-way ship to be on a course before the crossing rules could be engaged, as long as each ship was moving relative to the other in a manner that objectively viewed gave rise to a risk of collision. Now, in reaching that conclusion, the Supreme Court permitted Eversmart to depart from a concession which had been made below, to the effect that the crossing rule regime required Eversmart, as the putative stand-on ship, to be on a steady course before the crossing rules could be engaged. And indeed, there was quite a lot of case law that supported that position. What can be said is that the decision of the Supreme Court has required extensive rewriting of the relevant sections of Marsden on collisions. If we now go to the final slide, please. So what's the outcome? Well, the outcome is that the crossing rules applied to the encounter between both these ships to the whole of the relevant period of just under half an hour before the collision. Paragraph 147 is an important paragraph. They conclude, but it by no means necessarily follows, that this should result in some different apportionment of liability for the damage, or even responsibility for the collision having occurred. The case has now been remitted to Sir Nigel Tier for a decision as to whether the apportionment of liability should indeed be varied in the light of the Supreme Court's ruling, and that hearing will take place in November. So that concludes my topic, and thank you very much for listening.
Thank you, Vasanti, both for summarising so clearly and educating us so well on the development of that case as it went through and the decision of the Supreme Court, and for finishing on time, which I never manage when I'm presenting. So thank you on both fronts. Might I remind delegates that there is a Q&A function operating in the, or what has become the traditional fashion for online seminars. I'm not going to put questions to Vasanti now on her presentation. I'm going to call on Richard Sarll to address us first on his, and then collectively take any questions for a few minutes on either topic at the end of theirs, before we then move to a slightly different style of seminar and a slightly different type of presentation from Richard Gunn at the end. So on that basis, a reminder, please do post in the Q&A, and our technical operators will make sure those questions are fed through to me so that I can try to organise them and pass them on at an appropriate moment. Over to Richard S, as opposed to Richard G, to enlighten us as to some of the fun and games, not fun and games for the businesses involved, but perhaps fun and games to a certain extent intellectually for the lawyers involved, that the COVID pandemic brought to the cruise line industry last summer. Richard.
Super, thank you very much. Well, let's have the first slide up. Thanks, Mike. Well, many of you, I'm sure, will have attended the LMAA Spring Seminar on 19th of May. One of the points that was made by Bruce Harris, I think when introducing a speaker from the P&I Club, was whilst there is no doubt that there are many COVID-related issues out there, there haven't yet been very many arbitrations related to them, at least under the auspices of the LMAA. And I have a feeling that the experience of the commercial court may well be similar. But you couldn't say that about the Admiralty Court. And in fact, there have been quite a number of cases concerned with COVID that have already come through, that are given plenty for the new Admiralty judge and the new Admiralty registrar to get to grips with. Let's have a look at the next slide. There have been a good number of cases in the cruise ship sector, as Sir Andrew pointed out. Not all of them have been reported, but there's definitely been an uptick of cases generally. So you'll see then the number of claims issued in the Admiralty Court over the last decade or so. You'll see that in 2020, there was a good number, 200 claims issued. There were 14 warrants of arrest executed, and there were 8 sales by the court, which is an increase on previous years. Not quite so many as immediately after the credit crunch, but nonetheless, some good work there for us Admiralty lawyers. Let's move on to the next one. So although not all of the cases have been necessarily reported, we do have a trio of cases arising out of 2 cruise ships, which were owned by Carnival, but operated by the CMV group, which unfortunately went under. And the names of those 2 ships are the Columbus and the Vasco da Gama. And ultimately, those 2 ships were sold by judicial auction. Let's have a look at the background facts. Well, CMV was a relatively recent entry into the cruise ship market, which acquired older ships from Carnival. The Vasco da Gama and the Columbus were still in the registered ownership of Carnival, but Carnival was leasing those 2 ships, bareboat charter, essentially hire purchase terms, to CMV entities, to bareboat charterers. And there were instalments that fell due. Ultimately, the intention was that title to the vessel would be transferred. Unfortunately for CMV, COVID struck. There were no passengers who wanted to go on cruises, and they had to suspend their business operations in March 2020. In March, they contacted Tilbury, and they asked for a rate for the vessels to come and stay there and lay by. Come back to that later on. and the two vessels arrived then in Tilbury in April and May. Come July, some of the CMV companies went into administration, but not the two bareboat charterers. On the 21st of July 2020, however, CMV contacted the UK Coast Guard Agency and contacted the Bahamas Maritime Authority and said that they were simply abandoning the ships where they lay at Tilbury. And that meant that Carnival faced really quite a difficult situation. CMV were behind on the instalments that they were due to pay under the bareboat charter. In-rem claims were quickly accumulating. By late July, there were at least 4, but come the time of the judicial auction, there would be 3 dozen. Many crew members were unpaid, and of course port dues hadn't been paid, and they were increasing by the day. So let's move on to the next slide. Well, there she is, there's a Columbus. You can almost imagine it. Roll up, 2 lovely cruise ships, only 20 years old, perfect for all those passengers who want to take cruises in the pandemic year of 2020. Let's move on to the next. So Carnival needed a solution, but sale by private treaty was not really an option for them. For one thing, they couldn't give the usual warranty of the vessel being sold free of any encumbrances, what with all the rem claims piling up. And nor could they just defray all those creditors themselves, given how much the debts already were and what the vessels were going to be worth. In-rem claims, as I've said, were being issued as from April 2020, but none of the creditors were willing to come forward and arrest the ship. We'll come back to that. It may be that they thought, well, we're only suppliers of necessaries. We're going to rank very low. We might never get our money back. What's the point of arresting? Might also have been concerned that giving the usual undertaking to the Admiralty Marshal, that they would be liable for any costs and expenses incurred by the Marshal in realising the arrest and sale. Well, as for the port of Tilbury, they had no real reason to exercise their own statutory power of sale, to strength and sale as a port authority, given that they would have a super priority. I'll come back to what that means in just a little while. So what could Carnival do? Could they, and this is a tantalizing question, could they arrest their own ship and sell it that way, have it sold by the Admiralty Marshal? Well, in case that should have posed any problems, a ship owner arresting its own ship, they came up with a neat solution. There was a chart supplier who had a statutory right in rem. Might not have been worth very much, but still, it was a statutory right in rem. And a dormant Carnival special purpose vehicle called Popsil was used to take an assignment of that statutory right in rem from the chart supplier. Then Popsil could obtain the arrest, and it subsequently applied for an order of sale pendente lite, which Mr. Justice Baker granted. And the Columbus was then sold for about 5 million, and the Vasco da Gama was sold for about 10 million, but it still wasn't enough to cover all the claims. And that then gave rise to disputes between the various claimants as to whether each had valid claims or not. So let's move on to the next. So there are essentially 3 claims that received judgments which have been reported or available. First is that of the port, and there's the port of Tilbury in the background. Let's go on to the next. The port sought £2.5 million by way of port dues. And it was seeking that amount under a Queen of the South order. Now, the Queen of the South isn't here a reference to the well-known American crime television series, but instead to a decision of Mr. Justice Brandon, which sought to resolve competing powers of sale. On the one hand, you've got the port, it's got its own power of sale under its own legislation. And on the other hand, you've got the Admiralty Court having its power of sale under the Senior Courts Act. And what Mr. Brandon decided is, well, you can essentially buy off the port. Let's buy off its power of sale by having the Admiralty Marshal include the port dues owing to the port as an expense of the sale as part of his account. Once you've deducted all the expenses, then the proceeds of the sale can be lodged in court and everyone then can claim against it. And that gives the port, therefore, if you like, a super priority over all the other interests. And it doesn't really require the port to act with much expediency, because it's got a tidy little earner on its hands, given its status as having a super priority. How did this point arise? Well, on the 13th of March, as I said, contact was made with Tilbury. Could the vessels come in and take up lay-by berth? And this was agreed at a rate which wasn't particularly beneficial for the port, of £3,000 per week, as a reflection of the fact that there was an existing relationship. The ships then arrived in April and May. Come July, well, the port's concerned because CMV group companies have gone into administration. So on the 23rd of July, the port sent letters to the ship, notifying the end to the original tariff, £3,000, and instead the start of the published tariff for lay-by charges. And the question was, did the published tariff take effect? Now, under the original tariff, the port's claim was only worth £78,000. But under the published tariff, the port's claim was worth a whopping £2.5 million, about 30 times greater. Let's go on to the next one. It comes down to the effect of Regulation 5.6 of Tilbury's General Trading Regulations, which says that charges may be subject to adjustment at any time for extraordinary items or significant increases or decreases in volume, and or significant changes in delivery profile or storage characteristics. The company may also vary charges at any time upon giving reasonable notice to the customer. Now, this doesn't say anywhere that the charges have to be reasonable. And under the Harbour Act of 1964, ports can set whatever charges they think fit, subject only to challenge to the Secretary of State, typically by some industry body. So let's move on. The board argued that its fees could be varied on reasonable prior notice and that such notice had been given. The published tariff did not need to be reasonable. Instead, it was free to charge whatever harbour dues it saw fit, as you've seen. And the other parties, some cautioners, they argued that, well, first, reasonable notice had not been given, and secondly, it was implicit that the port could only vary the rate by a reasonable amount. The court held that the letter that had been sent on the 23rd of July operated as a notice to vary. Reasonable notice hadn't been given. That would have been 28 days rather than the smaller notice that had actually been given. Still, there was a claim for these port charges between 28th of August and the 16th of October when the vessel was delivered to the new owners. And the increase in port fees did not have to be reasonable. And the legislation permitted the port to charge such fees as it thought fit. Admiralty Registrar Davison nevertheless commented that the charges were very high. He said that they had been accurately described as being eye-watering. The overall recovery was, in his view, disproportionate. The port had advanced its already privileged position under the Queen of the South regime, yet its legal rights were clear. So let's move on from that to the second of the cases. And this is a claim brought by the bunker supplier. Move on. You can have the next slide. These were claims for 6 stems of bunkers, so were supplied in the first quarter of 2020 by an American supplier, WFS. And the claims derive from WFS's standard terms of condition, which are subject to US and Florida law. And the claims are for, firstly, fuel costs, Secondly, contractual interest on overdue amounts at 2% per month. Thirdly, an administrative fee of 5% of the principal amount once overdue, essentially collection costs. And fourthly, a contractual indemnity in respect of legal costs incurred. Now, it was common ground that the first of those, for the fuel costs, could properly be brought in rem. But some parties, particularly Carnival and Popsicle, challenged whether those other items, 2, 3, and 4, could be brought in rem or not. Let's have the decision. Next one. And this turned on the meaning of Section 22M of the Senior Court Act 1981, which refers to a claim in respect of goods or materials applied to a ship for operation or maintenance. And the court held that all of these claims, i.e. the items 1 through 4, could be pursued in rem. It was noted by Admiralty Registrar Davison that claims in respect of goods or materials should not be interpreted narrowly. The fees and the interest were incidents of the contract. As for that costs indemnity, well, that was further removed, but no less a part of the contractual bargain. And it was commented that it just didn't make sense to try and slice and dice and have only some of these claims pursuable in rem, whilst others had to be brought only in personam. So let's have the third of them now. This is the travel agent's claim. And if we can move on. The background to this is that travel agency services were provided from 1st of January through 31st of July for transport of crew. Now, the demise charters ended in early October 2020. You'll remember that the ships actually got abandoned in July, but the demise charters were allowed to run on until early October 2020, shortly before the sales of the ships. The sales occurred mid-October and proceeds were lodged in court. And the order for sale set a 28-day period for filing claims following advertisement in the ordinary way. Aspida, the travel agents, commenced their claims in early December 2020, so it's after the demise charters were terminated. And the question was, did the court have jurisdiction to entertain these claims, which were statutory rights in rem? Let's have the decision. Well, the decision turned on the meaning of Section 21(4) of the Senior Courts Act 1981, since these were claims for statutory rights of action in rem. And it was held that the relevant person, by the person who would be liable in personam on the claims, had to have been the charterer at the time when the cause of action arose and when the action was brought. But the demise charters had already been terminated by the time that the action was brought. So, although the claims were brought within the period prescribed by the court's order of sale, nevertheless there wasn't a valid claim because the requirements of Section 21(4) had not been met. So this is a bit of a qualification on what we saw in the Sanko Mineral, where Mr. Justice Tier observed, of course, the claimants must satisfy the conditions set out in Section 21(4) of the Senior Courts Act 1981 for enforcing admiralty claims in rem, but where the person liable is the beneficial owner of the proceeds of sale, he is to be regarded as the beneficial owner of the vessel for the purposes of Section 21(4). So if you had an in personam claim against the registered owner, you could bring that after the sale. But if you have an in personam claim against a demise charterer, you've got to bring that claim whilst the demise charterer still subsists. Something really just to be careful about going forward. So some final thoughts. Is it concerning, I mean, just putting this into context, we've had these important decisions on arrest and sale, and I feel like it's been a bit of a stress test of the system. Just two thoughts. Is it concerning that there were so many creditors out there that were unwilling to arrest these two ships, these sitting ducks? And secondly, is it concerning that courts can use the Queen of the South regime so much to their advantage? Thoughts to put out there. Thank you very much for listening.
Richard, thank you very much for that. Because of how time escapes us on these occasions, I'm going to leave both your questions and another question I might have asked you as rhetorical. I did want to pose one to Vasanti before we moved on more generally. Also, I should express my own vote of thanks to Vasanti, who's been working diligently while you were presenting, Richard, answering the very interesting and in some cases tricky questions that have been posed in the Q&A. So we won't take up time doing that on the webinar. But Vasanti, I did want to ask in relation to the Supreme Court's categorization, their Category 1, Category 2, Category 3. Well, on any view, Alexandra 1 was not a Category 1 ship. She was not heading from west to east, making a clean pass across the end of the channel. They said on their definition she was Category 3. What more or different would she have had to be doing to be within their Category 2 so that Mr. Justice Tier's decision that the crossing rules on the facts didn't apply would still have ended up being the correct result? And actually on that, picking up some of the questions you've been addressing in writing, is there a connection between that question and the modern phenomenon of the relative, if not extreme, lack of maneuverability of the modern very large tanker or the modern very, very large container ship, or as the case may be, bulker, in deciding whether you are, and if so, whether you are visibly to other shipping, a Supreme Court Category 2 or a Supreme Court Category 3?
Well, thank you very much for those questions. I think the action that would have converted Alexandra 1 from a Group 3 vessel into a Group 2 vessel is probably the alteration of course to starboard at C-5, which is the very thing we know she would have done had she not misinterpreted the VHF conversation some minutes earlier.
And I'm just pausing you there, sorry, and which, if she had done, actually would have then led them to be more or less head on to each other.
Well, no, in fact, there would have been an avoidance of collision in that circumstance, because he would have basically lined up so as to enter the channel on her starboard side, and Eversmart, although she was hogging the middle of the channel, there would have not have been a collision in those circumstances. So that's my understanding of how that differentiation on the facts would have arisen. But you're right to point out about the lack of maneuverability of large tankers. And it's really because action would have been needed at C-5, C-4, as the Admiralty judge held, to get her into the regime out of the crossing rule, that you needed to take action at that time, because that would have been the time required to line up suitably to enter the channel.
Yes, well, there are other questions I'd be fascinated to press you on, and I would in one sense be at liberty to do so because the reapportionment hearing is in front of Sir Nigel and not in front of me, but that's more to do with what will happen next, which fascinates me, and I don't think I should put you on the spot on that. And in any event, in view of the time, I'm going to move us on. I said at the start that I wasn't separately introducing our panelists, so I won't introduce Richard Gunn as an individual. What I will just say briefly is a little about what we now wish to discuss. And there our operator has put up the overview slide. And so this is to invite something of a panel discussion, which I hope Richard will be able to lead from his expert perspective primarily, of the recent developments, of which I imagine most, if not all of you, have heard at least something concerning the possible or actual threat to the continued existence and operation in the form in which it has for so many decades operated successfully of the Lloyds Salvage Arbitration Branch. And so I think I'm going to start the discussion, Richard, relatively generally, if I may, by saying that since everybody on the call today may not necessarily be completely up to speed, can you give us a little overview of what's been happening, where the process has got to, and in broad terms, what might be happening next?
Yeah, thank you, Sandra. Very happy to do that. It first came to our attention back, I think, towards the end of May, when it appeared that Lloyds were considering what it was that they were going to do as regards support for the Lloyds Salvage Arbitration Branch. They were, as I understand it anyway, Lloyds is re-evaluating its business for the next 200 or 300 years, having been around for the existing 200, 300 years, and how that should fit. And I think for them, they saw LSAB as somewhat as an anachronistic structure within a digital age, essentially sort of paper-driven. I'm not entirely sure whether that was a costs element or whether or not it was a strategic view, decisions that they were looking at reconsidering. The issue for that, of course, was losing support for Lloyds Salvage Arbitration Branch inherently brings with it a lack of support for Lloyds form of itself, at least to a certain extent. And it came to our attention because Lloyds initially just sought input from the arbitrators who have an arrangement with Lloyds. I suspect it's probably fair to say it's put it under those terms, regarding the periods during which they would be Lloyds form arbitrators. And the arbitrators themselves suggested that those questions as to whether or not Lloyds Salvage Arbitration Branch was something worth keeping should be extended out into the Lloyds Salvage Group. Now, there may be a number out there that aren't familiar with the workings of the Lloyds Salvage Group, and I should say a bit about that, I guess. Lloyds Salvage Group is unique in what it does globally. It consists of representatives of pretty much all of the international organisations that are interested in shipping business, not just salvage work, although obviously it includes those. So there's the International Salvage Union, there's the International Group P&I Clubs, there's IUMI, there's London Market, the International Chamber of Shipping, Intertanko, the Association of Average Adjusters, Property, the arbitrators themselves, the Admiralty Solicitors Group, which of course is a bit more London or UK centric. But anyway, this body meets twice a year, and they effectively manage Lloyds form. It's their subcommittees that draft the clauses and that manage SCOPIC. So that was put to the Lloyds Salvage Group as to what we thought about it. And it was generally the case that within all of those bodies, there was unanimous support for the continuation of LOF. And each of those bodies wrote independently to Lloyds, and also Lloyds Salvage Group sent a letter combining all of those interests, to which everyone signed up, saying how much they supported the continuation of LOF, and they thought that it would be a disaster for the shipping community should it be withdrawn. As a result of that, the consultation was extended to the end of June, and there have been no further feedback to Lloyds Salvage Group. There's unanimous support for the continuation of LOF. That's been put to Lloyds. They've had their meetings, they've extended their deadline, and we're now waiting for their final communication as to what their decision may be. And it may be that their decision will be to continue thinking about it and take further soundings and try and come up with a structure, I think, that suits all, rather than a diktat that suits them. So that's a summary of where we are at present.
Thank you. But before I then possibly bring in the other Richard and Vasanti for a comment or two, a follow-on question perhaps is this. If only as a matter of inertia, conservatism and familiarity, it may not be so surprising that there has been widespread support expressed. On the other hand, as you've summarised, that's a very wide and diverse, and in other respects, typically conflicting set of commercial interests all expressing, from what you've said, a unanimous degree of support that the Lloyds Open Forum system should not be put under threat. I mean, why so? Is it more than just conservatism and love of the familiar and not wanting change?
It is more than that. I think there are what I would call the three don'ts. Owners don't want to lose their ship. Clubs don't want a wreck to have to handle with, and underwriters don't want a CTL. And nobody wants pollution. All of that leads into a support for LOF, and there's a fear, and it's rightly so in my view, that absent the existence of LOF, which is a global form, then the consequences of casualties will be more severe than they currently are. And from a Lloyds perspective, in my view, and I think that Lloyds have got this now to the extent they might not have had it before, that a casualty is so much more than just damage to ship and cargo. If the insurance market within Lloyds is 10% marine, they might think, why are we supporting this? But actually, it's much more than that. If you think about the Wakashio, for example, or the Bonita, all of these, and more recently the Express Pearl, all of these casualties give rise to significant problems on coastal states, often in pristine areas. The pollution affects tourism, it affects trade, and in any event, all of those claims come back into reinsurance, which is heavily in the London market, and we all pay for reinsurance. And it also affects the environment, and we all pay for that, perhaps not in a fiscal sense, but certainly in a cultural and a global well-being sense. And so for those reasons, everybody has an interest in their ship, should it get into difficulty, being dealt with promptly, effectively, professionally, at a fair price.
Thank you. And I'm going to bring Vasanti in, not least because, if I am remembering, Vasanti, your CV correctly, you are a Lloyds Open Forum panel arbitrator, so you will have been one of those contacted initially who may then have been part of the message back to Lloyds that this required rather deeper thinking. Was an element of that a perception that you immediately had individually that what was being discussed could have the potential seriously to damage the Lloyds Open Forum as a contract, as a globally accepted norm?
Absolutely. I mean, looking back at the history, Lloyds Forum was developed at the beginning of the last century as a result of negotiations between the Committee of Lloyds and international salvage interests. And it sought to really balance the interests of both marine underwriters at Lloyds and salvors. Now, in my view, and I believe that all of the other panel arbitrators share my view, there is no other salvage contract that enables a vessel in a true emergency to get the necessary salvage assistance promptly without delay being caused by haggling over the price. And when you have haggling, you have delay, and that delay can be extremely detrimental to the interests of marine underwriters, damaging to the environment, and can risk injury to the crew. Now, in terms of the Lloyds Salvage Arbitration Branch, I mean, that has a reputation for being impartial. It's trusted by all the sectors of the industry users. And I fear that it's going to be very difficult to replicate that brand by another institution divorced from Lloyds. And to wind down the work of the branch would, in my view, be very detrimental to the interests of all concerned, including marine underwriters at Lloyds. And I'm not the only one to have expressed that view in the consultation process.
And Richard, Richard Sarll, any different perspective or similar perspective from, as it were, practitioners more generally who are not also the arbitrators? And B, do you agree with Vasanti, who I think in part there has also answered one of the questions that one of our attendees had posted in writing? that one doesn't see either in existence or on the horizon a viable alternative to the Lloyds Open Form and the system that operates around it.
I think that latter point has been very well addressed already by Vasanti and by Richard. One point I would make is I think we need to create a groundswell of support for LOF, and that includes, in my view, amongst junior practitioners. There haven't been that many LOF cases these last years by comparison with decades ago. I am concerned that legacy issues going forward, I think we need to get the junior bar behind LOF as well. Vasanti and I were speaking last year about having a marshalling scheme where junior practitioners can sit with LOF arbitrators in order to gain that experience. And I'm hoping that once COVID is that's more, we're back to normal, we'll be able to get that programme off the ground. But I think we need to go as a community all get behind LOF to ensure its future success.
And then back to Richard from other Richard Gunn. Is it? I'm being provocative because so far I'm hearing, unanimity of both concern and support for broadly the system as it is. But is it such a difficulty if ultimately an owner in any given location suffering a casualty is in a position to contract with local salvors on whatever might be terms being offered locally? If, as it were, the market in that sense fragmented away from a universal use of the Lloyds Open Form and became in, if you like, contract terms sense competitive again, or open market competitive again?
Yeah, thanks. I don't think it's a provocative question in that sense, and it's a valid question. And certainly Lloyd's consultation process has given rise to these sorts of questions within the market. I'm a fan of LOF for the reasons that Vasanti was saying. It's got a global footprint. It's known in the industry, whether you're a captain from the Philippines or whether you're a captain from Philadelphia. When somebody turns up waggling their LOF in front of you, then you know precisely what it is that you're getting into. And that brings with it, I think, brings with it a level of certainty and comfort, even though, in fact, you might end up paying more than you would like, and that's a different question, and no doubt we can get onto that in due course if we want to. But the concept of delay, which Vasanti touched on, is, I think, crucial in these terms. Delay in negotiating, delay in understanding, the concept of talking to one's owners, all build into them issues and difficulties that give rise to more severe outcomes, and finally a greater insurance burden. That's one reason. The second reason, if you like, and if I can jump to this, is to ask yourself, well, what would the alternatives look like? What is it that you've got with salvage, with LOF salvage, that if it didn't exist, how would things work? Now, it's quite right. There are local forms. There's a Turkish form, which some say is generally pretty expensive. I don't suggest that that's because the arbitrator's fees are based on a proportion of the amount that he awards, but it is regarded as being an expensive outcome. There's the Japanese form, which is widely used in the Japan market, and very successfully so. And there may be other ones that I'm not so familiar with. But if you want to see what local forms look like, and local issues can be, and how local things can give rise to salvage claims, you've only got to look at the ever given. Now, we don't know what the settlement sum on the ever given is. We do know that the amount that is paid will be somewhere between US dollars 150 million and US dollars 550 million, and those are public figures. I don't know how much of that is attributed, what the final salvage was, or even how much of it is attributed to salvage, because the authorities had separate claims within those sums. But that was a 6-day service, and this does not include the services of Smith, which are being bought independently of that. This was a 6-day service for a large ship in, frankly, very calm waters. My bath is choppier than the Suez Canal on most days. And I'm not suggesting that they weren't good services. They did a good job. They refloated it quickly, and it would have been very expensive, there's no doubt, if they had failed to refloat her, because the concept of getting in containers to cranes to deal with those containers have been well discussed in different forms with ultra-large container casualties. Fine, I'm not suggesting any of that. What I can say, though, is that even at these levels of award, whether it's the lowest or the highest end of that, that's an expensive service. And where there are those out there that say that LOF is expensive, I think, although I know that Vasanti probably can't talk about this in case she's retained in some way or was looking to be retained, but where in fact this to be a Lloyds form salvage, then I think it's extremely unlikely that the award for these services would have got to the sorts of levels that we will eventually discover has been paid in salvage. That is what is expensive. And whilst one might say, well, the Suez Canal Authority would never sign an LOF, so what are you going on about? That's the point, frankly, because once there is no LOF, then it's open to whichever contractor or individual or authority that is present in that casualty to contract on whatever terms that they wish. And that is a salvage convention settlement, if you like, within the confines of Egypt. So I think that the dangers in LOF, if you like, are real. They're very apparent right now. Or dangers of an absence of LOF are real and very apparent. And therefore, whilst owners are free to contract on whatever form they might choose to, they need to be slightly careful of how it might come back to bite them.
To set the scene for where we might take the discussion next, to what extent, over and above the other factors you identified at the outset, Richard, in setting the scene for us, to what extent has there been either an actual or a perceived decline in the use of Lloyd's open form worldwide, which, has the risk of becoming a self-fulfilling prophecy in the sense that potentially a declining use or a perception that there's a declining use of it fuels a perception at Lloyd's that the Salvage Arbitration Branch is not so necessary, fuels a lack of support, fuels a decline in use, and the thing escalates. But before getting on to the potential snowballing consequences, to what extent, what has there been either actually or at least in perception a decline in its use as an aspect of the underlying problem?
Yeah, there has been an actual decline in the use of LOF. If you look at the numbers of Lloyd's forms that there are now as to when, even 10 or 15 years ago, they reduced significantly. Don't have the precise figures as of today, maybe 35 this year or something, or maybe less than that probably, given that we're only halfway through the year. It's decreased significantly, there's no doubt about it. What has increased is the amount that has been spent on REC contracts. And I think that's interesting in that if one examines the rise of money that is spent on REC removal and compares it with the decline of money that is spent in Lloyd's form, I've carried out no study, but it's always struck me that that rise seems to follow with an increase in confidence and understanding of the use of SCOPIC. Prior to SCOPIC, there was no, if you like, industry set of figures relating to equipment and use of craft and the like. Now, SCOPIC was designed to deal with Article 14 and fair rate. It was not designed, as I understand it, by the international group in the ISU when it first came out. It was not designed for use outside of LOF, but its mere existence has enabled its use outside of LOF as a set of agreed terms. That makes negotiating an alternative contract to an LOF quite easy, because it's all there. You can go, let's do it on rec terms and annex in SCOPIC, on SCOPIC rates. So it's made it easier to negotiate. And I think that has fed into that decline in LOF, and we see that with the rise in the use of rec forms. But that's, if you like, the good side on one side. I know that the ISU would say there's nothing good about that because fair rates have got nothing to do with making a profit. They were designed for Article 14, but in terms of business, that explains where that goes from. The downside with this concept is to do with owners trying to negotiate a form in situations where they simply shouldn't do that. When LOF is the most appropriate contract, then that's what should be taken. And there are a number of cases recently, and I think one was recently reported on the Humber and by MAIB, where there were criticisms of the owners in delays in getting a salvage contract in, which led to issues as regards the casualty. And that's not the only time that that's happened, and there are other anecdotal evidence. In order to understand that, the international group has commissioned an independent survey to try and identify just why people aren't signing LOFs. What is it about LOF that forces them, or they feel compelled not to sign it and then try and negotiate something else? Now, I think that will be a very useful study, and it's not, they're doing it sort of independently, but they said that they will share that with Lloyds Salvage Group, and we'll then, as a group and an industry, we'll be able to understand more about the drivers behind people's fear of it, frankly. And so I think it's out there, but nobody knows quite why yet.
No, thank you. I mean, I can't not share, in case others haven't seen it, one contribution from Darius Gojcik, who says, and I think reflects at least the mood of your answers and Vasanti's and Richard so far, that frankly he despairs for the position of masters at sea in the absence of resort to Lloyd's open form. But picking up both on that thought and on what you were just saying, and perhaps asking Vasanti and the other Richard in turn first, and then I'll come back to you, Richard Gunn, to agree, disagree, or add. What is to be done if this is the target in mind to restore the more widespread, the more common use, to reverse any degree of decline on the back of what still seems to be this widespread industry support from different sectors of the world of shipping in the Lloyd's open form? What is to be done?
Well, I think there are probably two things. I mean, firstly, we've got to try and make sure that the Salvage Arbitration Branch operates commercially, so it isn't operating at a loss. And I don't know whether that is part of the thinking at the moment, why it's been treated as not core business of Lloyd's, because it's simply not profitable to keep the Salvage Arbitration Branch going. But clearly that cannot persist, and if we need to look at the financial side to make it self-funding, then that needs to be done. But I think the second thing is that people who sit as arbitrators, people like Richard Gunn, who is very active in the market and has numerous clients that would be potential users of Lloyd's form, to actually make others aware of its benefits. I know that at one time Lloyd's were, this is before lockdown, encouraging us whenever we went abroad to try and spread the message about Lloyd's form and how attractive it was and its ease of use, etc. And I think we
take a copy in your back pocket when you visited clients in Greece or Japan. Yes.
But I think those are two things that we certainly need to look at urgently to make sure that the Salvage Arbitration Branch does not close.
Yeah. Richard, Sarll?
Vasanti's mentioned kind of outreach and education, getting the word out there, explaining to people how it functions. And maybe I just add transparency as well. And at the moment, the awards are only available to those who've got a subscription to the Lloyds Arbitration Branch awards website. Why have this system any longer? In days where everything's open source, where you like to understand its workings, let's get the information out there so that people can understand it, see the operation of how awards are assessed and so forth.
I think that's a really good point, Richard, and I think anonymising awards and having them freely accessible is a great idea.
Yeah. Before Richard Gunn, you pick up on those thoughts, may I just add in another question to you, so that you then deal with that too. You mentioned early on in our discussion and picked it up a little bit later on. A specific point that I'd be interested in hearing more about, and that is the prospect of actually worse outcomes, not just, as it were, outcomes in the sense of where a salvage award in an arbitration or a foreign court or as the case may be ends up in numerical terms, but worse outcomes on the ground, salvage operations that end up not being successful when they could have been, or that end up doing more damage or the like. So as well as just picking up on the how do we reinvigorate thoughts that Vasanti and the other Richard have offered, perhaps then move if you would, the debate on a little as to why you are seeing those slightly more doom-laden possibilities also being there in the background.
Yeah, okay. Well, on the what Vasanti and Richard said, I agree with all of that. Education's the thing, of course, to a certain extent, although I often remember politicians, whenever I hear politicians saying they're not getting the message, I sometimes think I am getting the message, I just don't like it. But having said that, if you look at the reasons why people don't like LOF, it comes back to that concept of things being expensive, and educating people as to why it isn't expensive, I think is important. And just because somebody thinks something is expensive, that is actually just such a subjective view. It's about what you want to pay, not what it's worth or you should pay. And educating people on that concept, I think, is important. I like the idea of the salvage awards. Personally, it doesn't cost that much to go and get them anyway. There is a difficulty with anonymizing them and making them freely available, because within the salvage world, pretty much everybody knows who's involved in which operation anyway. It's quite a small market in that sense. But what about the sort of further issues then, the issues for the industry, I guess, in that sense? There were problems with it. There were problems with delay. There were problems with fears, if you like, of costlier services ever given, and all of these intertwine, I think, to provide ultimately more severe outcomes, worse outcomes than there might be. Without LOF, there is no global standard, and it's the global standard which actually works to cement the industry in place and provide that comfort and continuity. You don't want that plethora of local forms that I mentioned earlier. As soon as there's that uncertainty as to what's being offered, that gives rise to delay because somebody's going to consult with our underwriters and say, what does it mean? And they're not going to know. If they don't know what LOF means, they're not going to get to what some other jurisdictional or contractor's particular clause means. Those are significant problems. It means that it's costlier. They will be costlier. There's no doubt about it. There's no reason to assume that a local jurisdiction considering Article 13 with no experience on its local form is going to award less than a contractor on an LOF than an arbitrator would provide. That is wishful. It's not thinking. And so that's in itself builds into a greater uncertainty and would lead to the further decline of the salvage industry. How does that then pull together? If you've got no salvage industry, or if you've got a fragmented salvage industry, then what that leads to is, in my view, I think much more likely to lead to a greater increase in actual casualties with all the risks of environmental damage and the like that I spoke about before. If that were to happen a week or a month after Lloyds have decided that they're not supporting LOF, then that, in my view, would have a significant effect on Lloyds' global reputation. If they abandon LOF and 3 weeks later some ships run aground, it will have nothing to do with Lloyds, of course, but it doesn't matter. That's not what media and environmental issues are about. They're about raising awareness. And if there's a global player that an environmental group can point and hold up in order to raise the profile of that industry and that particular casualty and their wider aims, and I'm not decrying those aims, then they will do that. And that could have a significant effect on them. And it may be that they sort of get that now that they're sort of thinking about it in the wider context. I don't know if that answered the question.
No, well, thank you. In the way of these things, one's never quite sure whether to end a party when people are still having a good time for fear of generating a less good time by hanging on, or wait until the last few are still there looking for one more coffee. I note that our participation numbers have held wonderfully steady. We were at about 120. We've dropped off now to 100 and just now dropped back into only double digits. I think I am going to draw threads together at that point and say that firstly, on the last topic of discussion where we've been chewing the fat over the potential outcomes of the review of the Salvage Arbitration Branch and expressions of hopes as to where that will not lead. Obviously, we now wait with bated breath and see what Lloyds say of it. And then secondly, to say that, if I may, that I hope all of our attending delegates have enjoyed as much as I have the contributions from Vasanti, from the two Richards, have seen, as I certainly have, which is no surprise to me, how once again the London Shipping Law Centre, when it decides to put on a seminar, identifies properly expert speakers to provide a very high calibre of education and information, and in this instance as well, I hope, lively discussion and debate. Thank you very much again from me for inviting me to chair the discussion. I hope, operating remotely as we still are, it's been felt to go reasonably smoothly, even if we had one blip where we might have lost a sentence or half a sentence from Richard Gunn. Thankfully, that didn't turn into a permanent difficulty. And from me, therefore, thank you for everybody's attention. And Vasanti, I think it's back to you on behalf of the LSLC to wrap up.
Yes, well, as Sir Andrew said, it remains for me to say a huge thank you, first of all, to Sir Andrew for chairing everything so brilliantly, and to both Richards for their insightful and excellent presentations and debates. And thank you also to our delegates for participating, including with your questions, which have been very interesting indeed. So thank you all. Can I just mention that the next events of the LSLC to look out for will be on the 15th and 16th of September during London International Shipping Week, when LSLC is hosting a roundtable arbitration debate over 2 sessions, where 13 professional women from diverse sectors of the shipping industry will discuss and debate topical arbitration issues. So we all look forward to seeing you again soon, and please all have a safe and happy summer meanwhile. Bye-bye all.